8th.
According to her attorney, she's not a victim. So we'll let him decide how he wants to address his representation of her.
So it doesn't appear at this.
In the booking video from June 30th, Elizabeth Ciders was the only family member not in handcuffs. She cowered, her shoulders rounded, her body hunched. She looked scared. Her lawyer, Tommy Stolley, was asked if she was a victim. According to her attorney, she's not a victim. That was Prosecutor William Archer's response on July 8th. The paperwork already knew.
Elizabeth Ciders, the mother of 16 children, accused of hiding her children and causing them serious harm, wants out of jail.
Think of a filing cabinet drawer that was never opened, not because it was locked, but because no one wanted to know what was inside. That's the story of Elizabeth Ciders, the mother of 16 children, hidden from the state for years, now sitting in a county jail, and she wants out. Who wouldn't?
He has formally objected to any modification of Elizabeth's bond as it stands right now. Archer wrote in a memorandum opposing the request for bail modification. This court.
Before we go deeper into what the documents actually show, make sure you're subscribed to True Crime Court, because we don't just cover the story, we follow the evidence.
Wrote that Elizabeth Ciders has new serious felony charges that will be considered by the grand jury. That sounds like those.
Prosecutor William Archer has formally objected to any modification of Elizabeth's bond, and his reasoning is a window into the case we're not yet allowed to see. He wrote in a memorandum opposing the request that Elizabeth Ciders should stay in jail for 3 reasons. First, she's facing multiple serious charges, second-degree felonies involving serious physical harm to her children. That makes her a flight risk and a potential risk to the victims.
Consequently, she is at personal risk until her competency is known. Third, the defendant has new serious felonies.
Second, her own attorney has filed a competency motion. Archer argues that until her competency is known, Elizabeth is at personal risk. Third, and this is the line that should stop you cold, the defendant has new serious felony charges that will be considered by the grand jury.
Judge Rogers has already ordered a competency evaluation for Elizabeth Ciders at the request of her lawyer. The evaluation will also...
Did you catch that? New serious felony charges. These are in addition to the 16 child endangering counts she already faces. The paperwork already knew.
He's going to ask the grand jurors to indict her on new charges. So that makes me think this is in addition to those 16 child endangering charges. What does that say to you? Because I don't know what other charges. My mind is spinning. What other charges?
What else could a mother of 16 be charged with beyond child endangering? That question is the ticking clock in this room. Because if the prosecutor is signaling that more serious charges are coming, then what he knows and what he's about to prove changes the entire nature of this case. It's no longer a story about neglect and poverty. It's a story about a system that didn't see what was in front of it and a family that made sure no one would look.
In relating to the endangering children, but any other offenses that may have occurred while they're locked in this small room for many years. The key to this, I think, is, among other things, is it's long going.
Judge Rogers has already ordered a competency evaluation for Elizabeth, which will also assess whether she has a mental illness that could make her not guilty by reason of insanity. But a competency motion is a double-edged sword. It's a defense strategy, yes. But in Archer's hands, it becomes one more reason to keep her locked up. Because if she's not competent to stand trial, she may not be competent to be released.
Well, I'm quite sure he's listening to any jail calls by her as well as the others. They're permitted to do that and have a big sign next to the jail telephone that the calls are monitored. Typically.
Meanwhile, Vinton County is seeking permanent custody of the 16 children, ranging from age 18 down to just 1.5 years old. They are all in therapeutic foster care. The county isn't asking for temporary placement. They're asking for permanent custody. That's a signal. The legal standard in Ohio, as in most states, is the best interest of the child, and the state is telling the court, in writing, that reunification is not in the children's best interest.
I think you're exactly correct. This case, ordinarily this kind of case, even though this is a case of its own, exclusive kind, A case like this starts with a request for temporary custody to children's services, either on an emergency basis or otherwise.
A case like this normally starts with temporary custody, followed by investigation, evaluation, and a slow look at whether the family can be repaired. Here, they're starting at the end. The state has seen enough. The paperwork already knew.
Support. I'm not sure where she would go either. The crime scene itself, there's a whole lot of reasons where she doesn't have stability. Should she be released?
Archer also argues that Elizabeth is a potential risk to the victims, her own children. Her lawyer has said she wants to be reunited with them, that she loves them, that she's sending care packages from jail. But the prosecutor is not moved by that. He knows the children are hidden. He knows they are in therapy. And he's saying in court filings that if she gets out, she might try to find them.
Well, I think just by virtue of the fact that she is suggesting she wants reunited with the children, that should she be released, that she might make a effort to have contact with them. Obviously, the placements for the children would not be known, but
The bail she can't post is set at $300,000. Her lawyer has already said she has no money. Even if she could somehow raise it, she would be required to wear a GPS monitor. But anyone following these cases knows that ankle monitors can be cut off, tampered with, or simply ignored for hours before an alert is even seen. And that's assuming the GPS system monitors in real time, which in many counties it does not.
Or two, correct?
yes, that frequently will happen, at least here in Franklin County. The systems that they use, as soon as it is cut off, it sends an alert to the pretrial release program that then will contact victims and counsel and say that the GPS has been disrupted.
The prosecutor knows this. That's why he's not relying on technology to keep the children safe. He's relying on a jail cell. Archer is not playing a game of probabilities. He's looking at the evidence and saying, this woman cannot be free.
That is also why she might try and flee. And that's also why she might try and reach her children to talk to them, to influence them one way or another in what their statements may be.
The most striking thing in the memorandum is not what Archer says. It's what he implies. He didn't have to mention new charges. He could have kept that quiet until the grand jury met. But he put it in writing, in a public filing. That's the prosecutor showing his cards. He's telling the defense and the public that this case is larger, deeper, and uglier than the original 16 counts suggest.
No.
I don't know what other charges she could be facing. I don't want to speculate here, but I think that, it goes without saying, the prosecutor's already publicly said, these children were hidden. I mean, he said that to the county commissioners in a meeting. They were the hidden children of Omer Street. We
don't yet know what those charges are. The grand jury will convene, probably before Labor Day, and they will decide. But Archer has already telegraphed his intention. And if you read between the lines, the question is not whether Elizabeth Ciders will face more charges. The question is what the state has already found that we haven't seen.
Ron, they're not in school. They're not going to school. They're moving around to avoid children's services. Does this not signal to you that this goes beyond just being impoverished?
The defense attorneys have said, publicly, that the family is just poor, living in extreme poverty, moving around to avoid children's services. But the prosecutor's filing and his refusal to release Elizabeth says the opposite. He is arguing that this is not poverty. This is something else, something that required hiding 16 children from the state for years.
It wasn't just one discrete child endangering where a mother burned a child on the arm, and that's the basis for the single child endangering. This went on for years, where they weren't sent to school, where they were locked up, that they weren't allowed out, that their life was very much restricted. All those things add up.
This wasn't a single incident. The children weren't sent to school. They were locked up. They were not allowed out. Their lives were restricted day after day, year after year. That pattern, that long-going equation of neglect, is what the prosecution is now going to present to a grand jury. and that they're going to argue that Elizabeth Ciders was not a passive participant.
Tommy Stolley had said previously that Elizabeth Ciders wants to be released from jail so she can be reunited with her children, but that seems...
Her lawyer says she wants to be released to be reunited with her children. But the county is seeking permanent custody. There will be no reunification. The paperwork already knew.
And then we also have the competency issue that William Archer writes about, that basically she's at personal risk until her competency is known, because that's been raised by her counsel.
Right. And at least in terms of competency, they want to be assured that she's not a risk of harm to herself or to others. And that is...
We've watched this story unfold for months. We've seen the booking video, the hearings, the press conferences. But the real story is still in the documents, filed, sealed, and waiting. Prosecutor William Archer's memorandum opposing bail modification is public. You can read it for yourself. And when you do, ask yourself one question. What did the state know about Elizabeth Ciders before June 30th that we're only now beginning to understand?
Bail is currently set at $300,000. If she's able to post it, which her attorney has already said she cannot, she will have to wear a GPS monitor. And remember, you can look at all of the documents, peruse through all of them on our Law and Crime Plus app.
If you found this breakdown valuable, like, share, and subscribe to True Crime Court. And don't forget to turn on notifications, because we'll be watching the grand jury filings the moment they drop. This story is far from over, and the paperwork always tells the truth. Eventually,